Bankruptcy 101, ready, set, file, or not, as the case may be. I am Diane Wyrick. I am the senior staff attorney here at Snohomish County Legal Services. I do family law, I do bankruptcy, I do a little bit of this, a little bit of that. But today we're talking about bankruptcy and whether or not it's a good idea to file. If you're here, you're drowning in debt, or at least you feel like you're drowning in debt. And the options for dealing with debt, of course, is to pay it. That presumes you have the money to pay. You can negotiate payments with the creditor. That's assuming you have the money to pay. You can use what we call collection proof letters if your income is what we call judgment proof, which means you're earning less than about $500 a week, or your income is Social Security or some other kind of government money, student loan money, that sort of thing. That's money that cannot be taken from you for collection of debts. And then you can write judgment proof letters. You can ignore your debt and find out one day that your bank account has been garnished or your wages have been garnished. You can file bankruptcy. There is no one-size-fits-all solution. Bankruptcy, as you may know, is a right under the U.S. Constitution. Remember that we were colonized by many people fleeing debtors' prisons. You know, all those deadbeats over in England, they either had to go to debtors' prison or leave the country. So that's where a lot of us came from back in the old days. This is our government's one shot at compassion for the little guy. It's a bailout of the little guy. You know, the government has bailed out the banks, the car companies, the housing industry. They bailed out everyone. So filing for bankruptcy is a bailout of us, the little guy, to give you a financial fresh start so that you can proceed with your life and have a more quality life. However, you must follow court rules and procedures if you are going to take advantage of this right. And actually, many successful people have filed bankruptcy, including Honest Abe. Not only did he file bankruptcy, but he became president of the United States after he filed bankruptcy. You too could become, well, yeah, nobody wants that job. Okay, bankruptcy. There are different types of bankruptcy, and the two most common types filed by individuals are a Chapter 7 and a Chapter 13. In a Chapter 7, the court discharges or cancels debt that is owed as of the day your case is filed. This means you are no longer legally responsible for paying these debts. You get a financial clean slate and a chance to start over free of debt. Chapter 7 bankruptcy cases are open approximately 3 to 5 months. A Chapter 13 is the type of bankruptcy where the court puts you on a 3 to 5 year payment plan to repay your debts. That's because when you have a Chapter 13 case, you have enough income that you can actually be paying off these debts over the time. A Chapter 13 bankruptcy can help you try to avoid foreclosure of your home. It can help you pay off other debts such as traffic tickets or legal financial obligations, which are criminal fees and restitution. And those are debts that you may not be able to discharge in a Chapter 7 bankruptcy. If you earn too much money, the court's going to automatically try to have you file a Chapter 13 because they're going to want you to try to pay those debts back. But it's a pretty high level, and we'll talk about that in a minute. Please note that Snohomish County Legal Services can only provide assistance filing for Chapter 7 bankruptcy. Okay, so let's talk a little bit more about what a Chapter 7 is. This is the type of bankruptcy most people think of when they think of bankruptcy. This is the bankruptcy where you discharge, get rid of most of your debts. You can discharge your credit card debt, medical bills, civil lawsuit judgments. By civil, I mean non-criminal. So if you've ever been sued by a credit card company or for a medical bill or by a landlord or by somebody you were in a motor vehicle accident with, because they want you to pay for their their automobile injuries, etc. I mean, that's assuming this is not criminal. You weren't drunk driving when you were in that accident and killed somebody. That's a whole nother thing. But your garden variety civil lawsuit judgments you can get rid of. Personal loans that you've taken out, you can get those debts discharged. There are some things that are non-dischargeable. First and foremost, it's child support. Not that anybody wants to not pay their child support, right? You want to pay your child support and take care of your kids. Student loan debt is usually non-dischargeable unless the debtor can show undue hardship. And that's a very specific standard. If that's something you want to try to do, that's an action that you actually have to file inside your bankruptcy case. Federal income tax debt that is less than 3 years old, you're not going to get discharged. However, if you have a federal income tax debt that is more than 3 years old, you may be able to get it discharged. Legal financial obligations, LFOs, that's what I was mentioning when I was talking about criminal cases and criminal court fees, criminal restitution. Those debts are generally not going to be dischargeable in a bankruptcy. Traffic tickets and fines are not going to be discharged in a Chapter 7, but you can usually get rid of collection and interest charges. Those are usually dischargeable. So if you've had some traffic fines that have doubled or tripled because of interest and collection charges, you can probably at least get rid of that additional debt. So the question is, should you file? No one size fits all. Only you, the debtor, can decide. Is a financial fresh start something you need? Only you can decide. So ask yourself, if you're going to file, when? Well, don't wait until you owe an arm, a leg, and your firstborn if you can avoid it. And if you do, that might be the time to file. Ask yourself, have I lived in Washington for 2 years or for at least 180 days? If you've lived here for at least 2 years, you can use all the Washington rules and exemptions. If it's less than 2 years, you may have to use another state's rules and exemptions. You must have lived here for at least 180 days, that's 6 months, to even file in Washington at all. So if you've lived here 5 months, you're going to have to wait at least another month before you'll be able to file here in Washington. Ask yourself, do I have medical expenses coming up? Because if it looks like you may be going into further debt because of some big medical expenses, you might want to hold off on filing bankruptcy at this time because you're not going to be able to file again for at least 8 years. Am I going to be inheriting any money or getting a settlement from a lawsuit soon? Believe it or not, the bankruptcy court has an interest in money that you may be getting from an inheritance or from a lawsuit, if you're the one who's expecting money. So you're going to need to put those things in your bankruptcy as well. And if it looks like you're going to be inheriting a big chunk of money within 6 months of filing, you might want to hold off filing. Have I used my credit cards a lot recently? If you've used your credit cards a lot recently, especially in the last 90 days before filing, you are going to want to maybe not file for till it's been at least 60 days since you've used them, unless you have used them only for necessities. Ask if I get rid of my debt, will I have enough money for my daily living expenses? Remember, filing for bankruptcy isn't going to give you more income. What it is going to do is it's going to free up the money that you are now spending trying to pay all those old debts. A lot of people have gone into a lot of debt since the year 2000. I call it the year that wasn't. And so, this is something that if you don't have to pay those old debts, if that will give you enough money to now pay for your rent and your food and for a more quality life, it might be the time to file. Are my wages or bank account being garnished? If that's the case, you probably want to file sooner rather than later. And not only that, if you've had more than $600 garnished in the 90 days before you file, you can get that money back. Yeah, that's always a treat. Am I being sued for a debt I couldn't pay? Well, maybe you're not being garnished yet, but you think you're going to be garnished soon, so that might be the time to start thinking about filing. Am I being evicted, or am I worried about being evicted for non-payment of rent? Well, by filing bankruptcy, you can stop an eviction if it hasn't already, if it's not already in final judgment, where the court's already issued what's called a writ of restitution, and you're already supposed to be leaving your house in 3 days. But if you actually file for a bankruptcy, even a Chapter 7, it will temporarily stop that eviction. It might buy you a few more months. Same thing with a foreclosure. Have I filed for bankruptcy in the past? If you filed for a Chapter 7 in the past 8 years, you're going to have to wait till 8 years from the filing date of your last bankruptcy before you can file again. Am I going through a divorce, or have I been divorced recently? This is a consideration because we live in a community property state. And so you're going to just want to make sure you factor that question in as well. Has my driver's license been suspended because of an accident? If your driver's license has been suspended, or you've gotten a notice from the Department of Motor Vehicles that it's going to be suspended soon, you can actually use a bankruptcy to discharge the debt from that accident. And again, we're not talking about a criminal act. We're talking about a civil judgment where the other driver or the insurance company sued. Yes, you can then get your driver's license back by filing bankruptcy. But you must qualify. The first thing you're going to look at is something that used to be called the means test. And this is for debtors whose debts are primarily consumer debts. That's us. We are consumers, not business debtors. And we must qualify under a means test. It's not really a test. It's a financial calculation that determines whether you have enough income to pay your debts. And what the court does is it looks at your average income over the past 6 months, and then you'll annualize that income and say, if it was more than about $86,558 a year, and this is for a single debtor in Washington who earned less than $86,558 a year under the means test, would be eligible to file Chapter 7. That's confusing the way I said that, isn't it? Basically, if you qualify for my services, there's no way in heck you as a single debtor or a single one-person family are earning that much, because you wouldn't qualify for my services. So you'd have to be making a heck of a lot of money before the court would say, you know what, you need to file a 13. This is just for a household of one. Household of two, you'd have to be earning more than $101,000 a year for your family. So it's a pretty easy test to qualify under. There are time limits. As I mentioned earlier, you can't discharge debts in a Chapter 7 if you filed a Chapter 7 within the past 8 years and successfully discharged your debt. You can't discharge debts in a Chapter 7 if you filed a Chapter 13 within the past 4 years and discharged your debt. Also, you must have lived in Washington for at least 180 days, again, that's approximately 6 months, to file in the state of Washington. First thing you're going to have to do is complete a credit counseling course within 6 months before filing, and you must take this course from an approved provider. The providers that I mention here and that I provide links to are Money Sharp. I'm just going to go right here to show that to you. Money Sharp financial education courses before filing credit counseling, $12 per household. Click on that link, read all the disclosures. Come on. They tell you that it's going to cost $12 for either a single or joint filer if you both attend the same session. And that's, if you're a married couple and you're both filing. You can get a fee waiver if you cannot afford that $12, but you have to jump all their little hoops and apply. So that's Money Sharp. Oopsie, things you don't want to hear your doctor say. Another one is CC Advising. And they are now, okay, where is it? I need an account. And again, this is, they tell you that it's $49, but all you need is the basic text course, which is $14.99, and I can give you a code where you get $5 off. And that's per person. So if you're a married couple, you each have to pay that. So that would be $9.95 or $9.99 with my discount per person. So those are the two I mentioned just because they're inexpensive and nobody's complained about them to me. If you're not happy with either of those, you can go to this link and look at all these credit counseling agencies, fill out this information. You're in the Western District of Washington, you'll put that in there, the state, and then they will bring all these other courses up for you and you can see how much they charge. Some of them are going to charge up to $60. I don't know any of them that charge less than $10. You're going to take that certificate of completion and you're going to file the certificate of completion with your petition. So once you've completed that credit counseling course, if you're even just thinking about filing for bankruptcy, I'm going to recommend you take it because then you've got 6 months to file. And it's going to help you get your financial ducks in a row. So it's very handy for that. You're also going to have to complete a financial management or debtor ed course after filing. So you're not too worried about this one yet because you haven't filed yet. But just be aware that after filing, you don't get to sit back and say, I'm done. No, you have other things to do. And one of them is to complete this financial management course. And it has to be from an approved provider. I mention Money Sharp again because they do the first and last. Oopsie, sorry. Things you don't want to hear your surgeon say. Okay, sorry about that. I do this all the time. It would be so nice if I had a nice little clicker. Time limits. This is the speed one. Okay, and remember, please keep your microphones off until the end, unless you need to tell me something urgent. Okay, so we were talking about the financial management course. CC Advising does not have a second course, so that's why I give you the link for debtor $10 education, and that's $9.99 per household. So usually if you've used Money Sharp the first time, you're going to just stick to that because it's easiest. You don't have to register again. And again, if you would like to explore different management courses, financial management courses, you can go to this link, put in Western District of Washington, and apply and look at all of those. However, as I said, I don't know of any that are less than $10. This certificate you will file within 60 days of what is called your meeting of creditors. So again, don't worry about this course until after you get everything filed, because it's going to take you some time, a lot of paperwork to get your actual bankruptcy filed. And you can't do that until you complete the credit counseling. So here's some court rules we're going to talk about. Section 527A2 of the Bankruptcy Code. And I did include all of this in the email that I sent. So if you're able to print it out. Section 527A2 of the Bankruptcy Code says that all information you are required to provide with a bankruptcy petition and during a bankruptcy case must be complete, accurate, and truthful. Duh. I always say duh because of course it must be. You're filing this with the federal courts. You better be truthful, right? All your assets and all your liabilities must be completely and accurately disclosed in the documents filed in your case. And the replacement value of each asset must be stated in those documents after reasonable inquiry to establish such value. I'll talk more about that in just a minute. Your current monthly income must be stated after reasonable inquiry. And this was formerly called the means test. So you already know how that works. That's where they average your last 6 months of income. Last but not least, failure to provide the required income may result in dismissal of your case or other sanctions, including criminal sanctions. This is a federal process, federal court process, and it's serious stuff. So you're going to want to make sure you do it right. And that's why I'm here to help see you do it right. Okay, first of all, let's talk about how you value and list all of your assets. Well, everything you own, including your clothing, is an asset. So don't say, oh, I don't own anything. Yeah, you do. If you're wearing clothing right now, unless you're renting them or somebody loaned them to you, that's some of your assets. So you will determine and list the replacement value of your assets. This is not the cost to replace items with the new ones. Clothing, think of garage sale values. You're not going to list 5 pants, 6 shoes, whatever. You're going to go through your closet and say, okay, at a garage sale for these 5 shirts, maybe $5. And then I've got these 3 pairs of pants, maybe I'd get $3. So just total it up, and then you're going to enter it as miscellaneous. You may want to just enter it as miscellaneous clothing for debtor, including dresses, pants, shoes, etc., and then just put the total value. I think you'll find that your clothing at its current value is not worth a whole lot, unless you happen to have a sequined gown that you wore to the Oscars one year. That you might have to list separately because that's probably worth up to $600. Okay, value village prices. I suggest, as far as kitchen items, for example, take a walk through Value Village. Oh, look, there's a set of dishes, pots and pans, much better condition than mine are in. So if they're selling those for $20, mine's probably worth $10. Easy peasy. So don't overthink this. Just think about what, if you had to sell everything you own, what price could you get with it, for it, I mean. For motor vehicles, you're going to go to kellybluebook.com or nada.com. My car's value. That's all you got to do. And nada.com, I'm not as familiar with this site, but you can also get a value. That's all you got to do. For real estate, you're going to need a current market value, but you can start with looking at Redfin and your tax assessed value and your Zillow value. But if you have a lot of equity, like more than $700,000 worth of equity, and if you do, holy mama, that would be nice. Then you're going to need a current market value. You must make a reasonable inquiry to determine the replacement value of your assets. So, like I said, take some time, take a walk through Value Village, Goodwill, go online to eBay and see, make a reasonable inquiry to determine the value of your stuff. Let's just call it stuff because that's what it is, right? You're also going to list all your debts. If you owe it, you show it. You cannot pick and choose what debts go in your bankruptcy. So list all debts you owe, even if they aren't in your credit reports, and even if they cannot be discharged. Your mom, your dad, your Uncle Fred, none of them are more important than Credit One Bank. Yeah, they are more important. We know that, but the bankruptcy court doesn't think so. So if you have a loan to somebody and you really want to keep a relationship with that person, you're going to still put the debt in your bankruptcy, which means they're going to get notice. And then you're going to pick up the phone and you're going to call them and say, hey, mom, you know that $20,000 I owe you, I still intend to pay you back someday, but I'm filing bankruptcy and I have to put you in there, okay? thanks, Mama, love ya. Or if you have a dentist who maybe is working on your kids' braces, and you've been paying $50 a month, have to put that debt in there, and then you call the dentist and say, I'm still intend to pay this $50 a month. Just wanted to let you know, however, that I had to file for bankruptcy and I was required to put you in there, but I do want to let you know that I will continue to keep paying for this. When you file for bankruptcy and get your debts discharged, you get rid of your legal obligation to pay. If you feel that you still want to pay somebody back, even though you no longer have a legal obligation, which means they can't sue you, then that's okay. You can pay them back. And I'm certainly not going to tell you to do that with credit cards or anything like that. When you list all your debts, you're also going to provide a creditor mailing list to the court. And one of the documents that I sent to you, and one of the documents that the court will send to you, no, I sent it to you, that's right, is this creditor mailing list requirement. And it tells you that you have to prepare a creditor mailing list, and it shall be typed in a single column format that is left justified, no more than 5 lines, no more than 30 characters, et cetera, et cetera. And then they have a sample here. Left justified means this column is on the left. You've got 2 spaces in between, no more than 30 lines across or 30 spaces across, no more than 5 lines down, 1, 2, 3, 4, 5. So that's what that mailing list looks like. It does have to be typed. Even if you do everything else in your bankruptcy by hand, which is, like 60 pages worth of documents, so have fun with that. But you would have to type out your creditor mailing list. Minimum filing requirements. This is for emergency filing only. If you need to stop wage garnishment, if you need to stop immediate eviction, or to stop an immediate foreclosure action, or to stop loss of driver's license, then you need to just get your petition filed, your statement of Social Security number filed, and that certificate of credit counseling. You just file those things, you pay the filing fee, or you file an application to pay the filing fee in installments, or you file an application to have the Chapter 7 filing fee waived if you cannot afford that. So this link takes you to the United States Bankruptcy Court, and this is where they're showing this is your list of requirements. Complete your petition, complete your statement of Social Security number. They've got their poverty guidelines for Chapter 7 fee waivers. So if you're not sure whether you qualify or not, you can click on that link. So that's what you have to do just to get started, but you only have 14 days to get everything else filed. So you've got a deadline. Your creditor address list would be due within 7 days of your initial filing, and all other forms, and that's going to be about 40 to 60 pages, depending on how many debts you have, is going to be due within 14 days. So these emergency filings are really only for emergencies because you've got to really scramble. Other than that, you should have everything ready to file right away. And then after you file, you're going to attend your meeting of creditors. We call that the MOC. It is a required meeting with your bankruptcy trustee, and the trustee is the official that the court appoints to administer your case and determine if there are assets that could be sold to pay your creditors. The exemptions that we're going to look at later are very generous, and I can't imagine, well, none of my clients have ever had the trustee sell anything to pay their creditors. However, you must attend this meeting, and before you attend that meeting, the trustee must be sent documents before the meeting. He must be sent, and he is the gender neutral, he, non-gender specific. Trustees are men and women, so could be either. But you must send the trustee your federal income tax return from this past year. Statements for each of your financial accounts, payment advices, pay stubs, earning statements received from your employer within 60 days before filing. That's about 2 months. And an original signed declaration. These are what the documents, this is the declaration, and this is what the documents need to be sent are. Chapter 7 debtor's requirement to send documents to the trustee. After you file, the court's also going to send you this letter. And they're going to tell you to send this to your trustee and they'll also let you know who your trustee is. But I'm giving it to you now so you can start finding this stuff and make sure you have it. Your federal income tax return for the most recent tax year. So that would be let's see, this is 2024 return. And if you don't have that, then you need a written sworn statement as to why you don't have it. Notice that you get this to the trustee at least 7 days prior to your meeting of creditors, 341 meeting of creditors. So you're going to send them the tax return. You're going to send statements for each of your checking, savings, investment accounts. That includes the date of the filing of the petition. That means you're not going to already have that statement, right? Because if you file today, you're not going to have today's statement until the next statement comes out, right? So that's what you're going to send to the trustee. Payment advices, and again, if you don't have an employer, then you're going to provide a sworn statement as to why you don't have pay stubs from an employer. And you're also going to include this original signed declaration, which is attached here. This is the declaration. Please check the documents that are attached. So you'll say, yes, I've got my federal income tax return. I've got payment advices. I've got checking other. You may not have a federal income tax return. You may check other down here and write in statement regarding no federal income tax return. And you'll write that statement under penalty of perjury. And I can give you that copy so that you can do that. You're also going to need to make sure you have your picture ID and Social Security card. So if you don't have a driver's license or a government ID, any of these things, US passport, make sure you have a current picture ID from this list. And make sure that your proof of Social Security number includes all 9 digits. So the best way to do that is to have a picture of your Social Security card. If you don't know where your Social Security card is, this would be a good time for you now to replace it. Yeah. Medical insurance cards no longer have all the digits on them. Neither do pay stubs. W-2s usually do. So just get something official that has your entire 9-digit Social Security number on it. And those things also go to the trustee 7 days before the meeting of creditors. The details about your meeting of creditors is going to be in the notice of filing that is mailed after your petition is filed. So this is what this notice of filing is going to look like, more or less. Once the court has your creditor matrix, your creditor address list, they will be sending all your creditors and you a copy of this notice of Chapter 7 bankruptcy case. And it's going to have important information that you and your creditors are going to want to read. It's also going to have your bankruptcy trustee's name and address and contact phone number and email. And it's going to have the date for your meeting of creditors and the location. It's going to have all this information. So when you get this notice in the mail, make sure you put the dates on your calendar, put this notice where you won't forget it, highlight what you need to know. You will be getting that, and every one of your creditors will be getting that. The date of your meeting of creditors, it usually takes place 3 to 6 weeks after your petition is filed. And right now, it's being conducted by Zoom. Questions that the trustee asks you will be answered under oath, and they're very simple questions about your bankruptcy documents, your property, your debts, your financial condition. Questions such as, well, you'll be sworn in. over Zoom. And then you will be asked questions such as, did you carefully read all of the questions in the bankruptcy paperwork before you signed them? Are you responsible for the answers? And you should be answering yes, of course. And they're just very simple yes or no questions. If you own a home, the trustee will want to ask you more questions, probably, just to make sure that the trustee doesn't have an interest in keeping your house. Creditors rarely attend, very rarely attend a meeting of creditors because they know that there's no point. Your case will be dismissed without discharging your debts if you do not attend. So again, when you get that notice of filing, put all the dates right there on your calendar and make sure that you follow the directions in that notice. I did have this happen to a client who was not working with me until after his case was dismissed, because even though my agency sent him repeated reminders the week before his meeting of creditors, he still forgot to go. So his case was closed and it was like he never filed. There are protections when you file for bankruptcy, and probably the biggest one is the automatic stay. This automatic stay protects debtors from creditors, and it takes effect immediately upon filing. It stops or prohibits contact by telephone, mail, or otherwise to demand repayment. So your landlord can't show up on your door and say, hey, I just saw you filed for bankruptcy. You need to give me some money. No, it stops immediately upon filing. It prohibits action to collect money or obtain property from you. It prohibits the start or continuation of lawsuits or foreclosures. It prohibits or stops garnishment of bank accounts or wages. So this automatic stay is very, very important. It is protection from creditors. Once you have filed, if you get a phone call from a creditor, just interrupt them and say, oh, hi, you know what? I filed for bankruptcy on such and such a date. Here's my case number, Western District of Washington. You can look it up. Thank you. Goodbye. That's all you need to do. And as soon as they hear the word bankruptcy, they should leave you alone. Okay. So that's the automatic stay. The bankruptcy exemptions are another huge protection. Exemptions are the laws that allow you to keep most, if not all, of your property. There are federal exemptions and Washington state exemptions that you can use in the state of Washington. The federal exemptions, if you don't own a home and you don't want to use the Washington state homeowner exemption, then you probably just want to use the federal exemptions, because the wildcard exemption protects up to $15,425, including cash. We'll look at it in just a minute. And the Washington state exemptions, if you are a homeowner, you can protect equity of up to the county median sale price of a single family home. And in 2023, that was $725,700. If you have that much equity in your home, you can protect it if you use the state exemptions. However, note that debtors cannot pick and choose between federal and Washington state exemptions. They must have lived in Washington for 2 years to use our exemptions. If you've lived in Washington for fewer than 2 years, you may have to use a different state's exemptions, and some states do not allow the federal exemptions. Here's the state exemptions. You can see that homestead exemption is very generous. Household goods, you can own up to $6,500. This includes all your used furniture, your kitchen items, your linens, your bedroom items, furniture, blah, 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 etc. And again, this is the used value. The used value. There is a $10,000 wild card, and if you have a car that's worth more than $15,000, this might be worth it to you too. So these are the Washington exemptions. The federal exemptions, we've got a lousy homestead exemption. So you don't want to use this if you're trying to exempt your home. But your personal items, all your personal items, up to 14,875 in the aggregate. And that's doubled for married couples. So again, that's a lot of stuff. That's a lot of really nice furniture and a lot of really nice everything. So unless you've got a Picasso on the wall, I'm guessing you're not going to have any problem exempting what you need to use. And the wild card exemption goes up to 15,425. So, if you've got 12,000 bucks in savings, you should be able to exempt or keep that. So again, these exemptions are very generous. Are there consequences for filing bankruptcy? Well, yeah, you could lose non-exempt property, but as we just saw, our exemptions are very generous. And there are federal and state options available if you've lived in Washington for at least 2 years. If you've lived in Washington for under 2 years, you may have to use a different state's exemptions, but most states have pretty good exemptions. Your credit report is going to reflect that you filed bankruptcy for 10 years. That may do possible damage to your credit score, but if you're considering filing bankruptcy, you probably already have a credit score that is in the toilet. And remember that after you get your discharge, your credit report will show $0 debt owed after discharge. So I do have clients that I know called me 2 years after filing bankruptcy just to let me know they purchased a home 2 years after filing bankruptcy. So as long as you are starting to, as long as you get your financial fresh start and you continue to avoid going into huge debt, you should be just fine. Warnings when you're filling out your paperwork. Preferential payments. These are payments made to one creditor, just one, in the 90 days before filing, or payments made to friends or relatives in the year before filing. These are payments for debts owed. That's what we're talking about. So let's say you were making $400 payments to one credit card and paying none of the others because you just want to keep one. Well, if you've paid more than $600 in the 90 days before filing, then you're going to want to wait another month or two until it shows that you have not made any more payments to them. And payments to friends or relatives in the year before filing. I've had people file their taxes, pay their mom back $1,000 that, she loaned you before you filed for bankruptcy. I mean, before you filed your taxes. I'm going to tell you, get that $1,000 back from mom and exempt it. You can exempt it. Otherwise, the trustee has the right to get that money back. And the only kind of preferential payment that you can get back is if that includes garnished wages or bank accounts that were garnished in the 90 days before filing to the tune of $600 or more. You also want to be aware of fraudulent transfers. You should not be selling property at below market price or give away expensive items to a friend or relative within 1 year of filing. So, you've got that $10,000 car that's paid off and you decide, yeah, I'm just going to sell that to my brother, wink, wink, for $500. Well, that's what we call fraud. So make sure you're not doing anything that's going to wave red flags. If you think it's going to wave a red flag, talk to me about it and I'll tell you what to do, which is probably going to be wait to file. Warnings, trying to keep a credit card, just say no. If you owe it, you show it. If you owe so much as $5 on a credit card, you're going to want to put that in your bankruptcy. That's my grandson. That's him in the card when he was a little guy, and then him when he's 10 and he's 17 now. I put the current photo in there because that would be creepy, right? Okay, here's our timeline first and foremost, credit counseling, right? You're going to want to take that credit counseling. I suggest Money Sharp and or CC Advising. If you are able to download my PDF, you should be able to click on any of these links and they'll take you to the links. After you've taken your credit counseling, you're going to complete your forms. And there's a couple ways to do that. One way to do it is by going to the Western District of Washington, United States Bankruptcy Court website. This is an excellent website. They've got links for filing without an attorney, getting ready to file. They've got the checklist of all the forms you have to file. They've got packets that are like 100 pages long. Oh, 91. It's only 91 pages. And then they have instructions, which are 40 pages. So I'm trying to save you from having to deal with all that by pointing out the important stuff. But, oh, they just updated it April 2025. All right. I haven't seen it since then. But you are welcome to click on this and download everything. It's got all your minimum requirements, and then it's got where you file. Notice that there are electronic filing option for parties without an attorney, so you don't have to go all the way to Seattle. You can just submit PDF documents and upload them. It's so nice. It's so nice. And if you have trouble knowing how to do that, I am happy to help you because it's just a nice option. You can also mail your stuff, but that's going to cost you about $10. So that's what the forms are going to look like. And there's a bunch of them, as you saw. Or you can go to Upsolve, which is a nonprofit, wonderful nonprofit app to prepare your forms for free. So you're going to want to take the screener and get started, fill everything out, leave page. I'm just going to sign in for me so I can kind of show you what some of it looks like. Go to Tool, complete your questionnaire, continue your questionnaire. Basically, all you're doing is you are answering questions, and then they are going to use those answers to actually print up these forms. So this is what the petition looks like. Instead of you having to go through and type in every different, or even handwrite, print every different item, you just put your information in the questions and it's going to fill out the forms for you. It is a wonderful website. It also answers a lot of questions. So everything I talked about today, you could probably ask, what was she talking about? You could probably find an answer on Upsolve. It's a really good site. So I'm going to highly recommend that to you. But once you have completed those forms, you will file your case, right? And then about 30 days, usually, as I said, 4 to 6 weeks after you file your case, that's when your meeting of creditors is going to take place. And don't forget to send documents to the trustee before that meeting, right? Also, after you file your case and before you can get your discharge, it does not have to be after your meeting of creditors, just anytime after you file your case, you need to take that financial management course. And again, I had the $10 debtor education course or Money Sharp. And I usually recommend as soon as you've filed your case, while you're waiting for your meeting of creditors, as you're getting your documents together, get that financial management course done. I did have a client who did not take his course, even though he was reminded by me and by the court, and his case was discharged. I mean, was not discharged, it was dismissed, and his debts were not discharged. About 60 days after the meeting of creditors, your debts will be discharged, and a few days after that, the court will close your case. So that's your timeline. Can you file on your own? Well, you betcha. You just need a big gulp and a big pencil. I'm going to suggest you go to annualcreditreport.com, unless you use Upsolve. If you use Upsolve, they will pull your credit reports for you, which is a blessing because they will also download them automatically into your creditor matrix. You don't have to create it yourself. But if you're not using Upsolve, and you can also do your credit counseling course through Upsolve. I think it's a $14.95 fee, but I would do it. I would do it. They don't do married couples. So if you're a married couple, talk to me about how that works. Request your free credit reports if you need to from annualcreditreport.com. You can get free weekly credit reports from the only source authorized by federal law. So it's probably the safest way to get them. You can get one from Equifax, one report from Experian, and one from TransUnion by using annual credit reports as your doorway. So even if you are not able to get all of them, you're denied one of them, repeat the step for the other ones, because sometimes you may be denied by one of them for some weird reason, and you can get the other one or two. So again, if you don't use Upsolve, then you're going to want to get your credit reports. Again, there's Upsolve. I cannot tell you how highly I recommend this. I really cannot. And it's free. It is absolutely free, except, you have to pay for your credit counseling. You can also go to the United States Western District of Washington site and click on filing without an attorney or the for debtors links. And they've got all this information for you. They've got all these forms and checklists. They've got lots of ready to file, frequently asked questions, electronic filing options, et cetera, et cetera. So that's an excellent place to start. WashingtonLawHelp.org. If you're wondering, this is not absolutely the best place to go for bankruptcy judgment proof. Their website is new. Judgment proof debtor. Let's see if that pulls it up. Child support order. Nope. Okay. Debt. Okay. Answer debt. They've got letter to debt collectors, letter to collection agency. This will tell you in Word or PDF that you are exercising your rights under the Fair Debt Collection Practices Act, et cetera, et cetera. This is what you need to do because you are judgment proof, because your income is protected is protected and you don't own anything that you cannot exempt using the Washington state exemptions. So, you can even own a car that's worth $15,000. It used to be $4,000. So again, WashingtonLawHelp.org can help you with that if you decide not to file bankruptcy. It also has links about bankruptcy. And there's our shark, because attorneys are all supposed to be sharks. But as you can see, you got to love me. But you don't need to use an attorney. You can do it yourself. So here are these exemptions again. And here's to a financial fresh start.